Welcome to The Explainer. Today we're diving into a topic that forms the absolute bedrock of real estate finance in Africa's largest economy, Nigerian mortgages. Now, if you think creating and enforcing a mortgage is just a standard, one-size-fits-all process across the whole country, well, you're in for a serious surprise. The laws governing Nigerian mortgages are intensely complex. They're heavily jurisdiction-specific and completely dependent on where exactly your property sits and what kind of interest you actually hold. It's like navigating a giant legal puzzle, really. And today, we're going to map out those strict rules that could literally save or cost you millions in a real estate deal. So here's our roadmap for today. We're going to cover the three mortgage jurisdictions, creating legal mortgages, the equitable alternative, exercising the power of sale, and finally, bypassing the governor's consent. Let's just jump right in. Section 1, the three mortgage jurisdictions, mapping the law. Okay, the very first thing you've got to understand is that Nigeria doesn't have just one single unified mortgage law. No, the legal landscape is actually fractured into three entirely distinct geographical jurisdictions, and these dictate exactly how you have to structure your transaction. At the top, you've got the CA jurisdiction, which is governed by the Conveyancing Act of 1881. This covers the old northern and eastern regions. Then in the middle, we have the PCL jurisdiction, using the Property and Conveyancing Law of 1959. That covers the old western and midwestern regions, places like Oyo, Ogun, Edo, and Delta states. And finally, sitting completely in its own legal bubble is Lagos State. Lagos is governed by its own Modern Mortgage and Property Law, or MPL, from 2010. You absolutely must know your jurisdiction before you even think about drafting a deed. Moving on to Section 2, creating legal mortgages, the heavy-duty security. Now, a legal mortgage is basically the heavy-duty security of the lending world. It transfers actual legal interest, giving the lender the strongest possible protection. But the methods for creating one change drastically depending on where you are on the map. If you're in the northern or eastern CA jurisdictions, just remember the acronym ASS for the three ways to create a legal mortgage. A is for assignment, where you transfer the entire unexpired residue of the mortgagor's interest, subject to a proviso for redemption. S is for subdemise, which basically means granting a lease that's at least 1 day shorter than your own term. And the last S is for statutory mortgage by deed, using a very specific form straight out of the CA schedule. But watch what happens when we move to the western PCL states. Our little mnemonic shifts from ASS to SCC. Notice we're abandoning assignments completely here. Why? Because under the PCL, you simply cannot create a mortgage by assignment. Instead, you use a subdemise, a charge by deed expressed to be by way of a legal mortgage, or a charge by deed expressed as a statutory mortgage. This whole shift was actually designed to prevent the mortgagee from getting stuck with onerous covenants in the head lease. Pretty clever, right? Then Lagos State throws a massive curveball under the MPL. In Lagos, you can't just look at the geography. You really need to know the exact nature of the property interest a mortgagor holds. Are we talking about a right of occupancy, which acts a lot like a freehold? Or are we dealing with a leasehold interest? The document you draft is entirely dependent on the answer to that specific question. So if you're dealing with freehold-like rights of occupancy in Lagos, you're going to use the DCC method to secure your legal mortgage. D stands for demising the property for a term of years absolute. And the two C's stand for using a charge by deed expressed by way of legal mortgage or a charge by deed expressed by way of statutory mortgage. DCC. Conversely, if the property in Lagos is a leasehold interest, well, we actually revert right back to the SCC method, which is identical to the PCL states. Use subdemise for a term of years absolute, making sure to keep that absolutely crucial 1 day reversionary interest, or you use one of the dual charge options, a charge by way of legal mortgage or a charge by way of statutory mortgage. All right, Section 3, the equitable alternative, the simpler path. Let's say you really don't want to deal with strict statutory forms and all those rigorous perfection processes. Well, equitable mortgages are your universally simpler path. Across most of Nigeria, merely handing over your title deeds with the explicit intention to secure a loan creates an equitable mortgage. No complex deeds are immediately required. It all relies on this equitable principle that depositing the deeds implies an agreement to execute a legal mortgage if you're ever called upon to do so. You can also use other methods, like a mortgage of an equitable interest, or an agreement to create a legal mortgage under the famous rule in Walsh v. Lonsdale. They're faster, they're cheaper, and they are fantastic for short-term lending. But notice the stark contrast here. Lagos adds a really strict twist. Section 18 of the Lagos MPL requires that an agreement to create a legal mortgage absolutely must accompany those deposited deeds. You can't just hand over the papers, shake hands, and walk away. Plus, in Lagos, if the borrower refuses to sign a legal deed later on, the lender actually has the right to approach the court within 30 days via an originating summons to force them to execute it. Lagos definitely does not leave these things to chance.
Section 4. Exercising power of sale, getting your money back.
So, what a borrower defaults, the lender obviously wants their money, and that usually means selling the property. But we need to clarify a massive legal distinction here, the difference between a power of sale arising versus becoming exercisable. Think of the power arising as unlocking a closed door. The legal potential to sell is there, the lock is disengaged, but you can't legally push the door open and walk through quite yet. The power becoming exercisable, on the other hand, is actually turning the handle and stepping through to sell the property. You must have both before you can put that land up for auction.
Now, to merely unlock that door and have the power arise, 3 very specific conditions have to be conjunctively met, meaning all of them. First, the mortgage must have been created by deed. It's a statutory power after all. Second, the legal due date for redemption must have passed. If that date hasn't passed, the door is staying locked. And third, there must be no contrary intention written in the deed that explicitly forbids the sale.
Okay, pay very close attention to this number, 2. 2 is the exact number of months a borrower must be in default in Lagos State before a sale can happen. This is a huge deal because it contrasts sharply with the Conveyancing Act and PCL jurisdictions in the rest of the country, which actually require a 3-month default period. So to actually execute the sale in Lagos, to turn that handle and throw the door open, any one of these 3 disjunctive events must occur to make the power exercisable. 1. You serve a notice requiring payment, and there's a default for at least 2 months. 2. Interest payments are in arrears for at least 2 months. Or 3. There is a breach of a fundamental term in the mortgage deed or the law itself. If literally any single one of these happens, the lender has the green light to sell.
Section 5. Bypassing governor's consent, cutting the red tape.
Let's look at the final, often dreaded hurdle of perfection. Under Section 22 of the Land Use Act, a holder of a statutory right of occupancy simply cannot alienate their interest by mortgage without the prior consent of the governor. And, as established in the landmark case of Savannah Bank versus Agelo, without that consent, your legal mortgage is effectively void. This makes it a massive, time-consuming bottleneck in the lending lifecycle. Honestly, navigating this bureaucracy can sometimes feel like trying to solve a Rubik's Cube blindfolded. Which brings up probably the most practical question for any lender or borrower out there. When exactly is this time-consuming, highly expensive consent legally unnecessary? What are the loopholes baked into the system? Well, fortunately, there are 6 major statutory exceptions where parties can proceed completely safely without knocking on the governor's door. You don't need consent for mere equitable mortgages or just mere loan agreements. If you already got consent during the equitable stage, you don't need to get it again to convert to a legal mortgage. You don't need it to reconvey or release the property back to the borrower. For non-urban lands, you only need local government consent. And lastly, you don't need it for something called upstamping. Now, upstamping is an absolutely fantastic tool. It refers to paying additional stamp duties on an existing mortgage deed to cover new loan facilities between the exact same parties on the exact same property. It is incredibly efficient for businesses because it allows banks to extend further credit without having to start that grueling governor's consent process all over from scratch. As we wrap up, I want to leave you with a bit of a provocative thought. If the actual alienation by mortgage requires strict state consent, does bypassing it via an equitable mortgage leave the lender truly secure when the worst happens? That tension between the commercial convenience of skipping the red tape versus the ultimate legal security of a fully perfected legal mortgage is the defining balancing act in Nigerian real estate finance. Thank you so much for joining me on this explainer. I hope mapping this out brought some much-needed clarity to the real complexities of Nigerian mortgages. Until next time, keep learning.